So we'll, I guess, kind of pick up where we left off.
Right. Thank you, Mr. Chairman. Thank you, members. So I'm not really sure where we pick off. I don't know if you want me to go on closing. I know we have the fiscal note. I've printed it out. I know it said there may be an expense up to, I think, $1.4 million. I think their final say was that it's undeterminable, and I believe they recommended that it do refer to finance. Is that how that works?
Yep. Yeah, it would automatically be. It seems, best I can tell, it seems like some of the similar issues in terms of from their perspective, I'm not speaking on behalf of the fiscal office by any means. I'm just kind of reading through what they've written, but they have a lot of indeterminable parts. So they show increase, but to what extent they really can't determine. And so that was what they pretty much put forward in the fiscal note. One interesting thing, and I don't know, maybe you can speak on this. I thought this was interesting from the perspective of the Office of Risk Management, and they put that ORM reports that it may realize an increase in damages resulting from more suits going to trial as a result of the lower civil jury trial threshold.
Yeah, I saw that too. I don't really know.
I don't understand. I mean,
respond to that.
I didn't know if you would be able to. We have a couple lights on. Maybe somebody has some thoughts on that. Senator Martini.
Thank you, Mr. Chairman. Members, as I appreciated, you were about ready to close when Senator Luno requested the fiscal note on this thing. As I understood your testimony last week, you said that by passage of this legislation, there would be less trials. Is that your opinion?
My opinion is that having the 2-year prescription in the bill, from everyone that I've spoken to, seems to believe that will result in less lawsuits being filed and that more cases will be settled because you're giving it an extra year to do that.
Yeah, but once that first year passes, you're back with the.
I agree, but
go ahead. I'm sorry.
No, that's it.
The fiscal note says, to the extent that a 33 to 50% increase in civil jury trials, that's their projection. That's what would
right. But I don't think they're taking, and I don't think it's possible to take into consideration the extension of the prescription period, because I think that would work hand in hand in lowering the amount of lawsuits. And if you look at, we're only one of 3 states, right. I believe it's Kentucky and Tennessee, that have a 1-year prescription period. Everybody else is 2. Some states are up to 6, and I'm certainly not advocating.
Well, my practice, I like the 1 year, but I think most of a lot of these members like the 1 year too. But as I appreciated what they call it, the omnibus premium reduction, in order to get the premium reductions, or to hopefully realize that, all of this has to pass: the prescriptive period, jury threshold. Seatbelt. Is seatbelt in this?
Seatbelt is not in this bill.
Collateral source. My point being is there is an anticipation that we will have more jury trials. I know that, and I'm not going to speak for the judges, but the ones that have spoken to me have said we already don't have, and the DAs, we already don't have enough time to try the cases that we have, civil and jury. So obviously we're going to have to have Senator Donahue's business courts in there, and the new Pfizer courts and the vaccine courts. And I guess, can you get a jury trial in a vaccine court? I'm trying to think.
Maybe, I know you're term limited. Maybe you can run for vaccine judge. I don't know if we have a specific judge for that.
It's meetings such as this that tell me don't run again for anything. So, but anyway, I just think that the fiscal note seems to suggest that, contrary to what we expect, there will in fact be more jury trials, not just in accident cases.
Right.
But every time, if everything passes, every time there's a $5,000 dispute between a contractor and a homeowner, they can get a jury trial.
And again, I believe I said it last week, if you want to amend it up to $25,000 or take jury trial threshold out, you know, I'm willing to work with anyone
How
on
would
this
that,
committee.
but how's
to
that
get-
going to affect the premium reduction? Have you
Well,
got
I
a
think,
number on
I don't
that?
know if there's one home run here. I think it's a
Bunch of singles, huh?
it's a bunch of singles. I don't know. I wish there was the one home run, because I would run with that bill, but, you know, I'm just trying to help the situation. So if there's any way.
Well, there's an
member-
empty seat next to Senator Donahue if you want to come up and take a few punches. Yeah, we're getting tired of beating on Jack, so thank you.
Thank you.
All right, Senator Donahue.
Thank you. So, looking at the fiscal note, I thought it was interesting, just as Senator Martini did. ORM staff reports further that increased prescriptive periods may reduce its ability to investigate claims against the state. Now, if you add a year to the period of time, do you decrease your ability to be able to investigate? It seems like you doubled it, which may lead to more settlements with aggrieved parties in lieu of pursuing a jury trial.
And I'm not speaking for it, but from what I understand is some people will say that when you have 2 years, if nothing's ever brought to their attention till maybe a year and a half down the road, they've not been able to position themselves or prepare themselves to have a proper defense. And then at the 18th month mark, they're presented with a lawsuit and they're completely caught off guard or unprepared, and so they have to.
But Senator, I would say that's true whether it's 1 year or 2 years. You're still caught if you filed 6 months.
I'm not arguing for one
No,
side or
just-
the other. I'm just saying I think that's what they're getting at there.
Well, I'm just worried about the logic of. I tell you a question. I've been reading fiscal notes for 12 years, and is the person that wrote this fiscal note in the room? You want to come up? Is that all right, Mr. Chairman?
Oh, absolutely.
Zach Rao, Legislative Fiscal Office.
Yes, sir. How are you today?
I'm good, Senator Donahue. How are you?
Good, thank you. So, you heard the chairman's explanation of the increased prescriptive period.
And that was
what do you-
my guess.
Pardon me?
That was my guess, not my explanation.
Well, I'm going to listen. I think it was a good explanation, but for years we've been hearing, well, if you increase the prescriptive period, it's going to reduce cost, and now I'm reading that you think it wouldn't reduce cost. So
When I discussed it with the RM staff, the explanation they gave me was very in line with what Senator Ward said. Essentially, that when they get notice of a suit, they generally get the first mention of a claim when the suit is filed. So
which could be 364 days.
it could be 364 days. Personally, I was involved in a car accident. I was sued 364 days after that occurred, and it could be, under this legislation, it could be 700 plus days till the state gets notice of a suit, which when I discussed it with the RM staff, they said it might impede their ability to do a fact-finding investigation to prepare an adequate defense. Like the
because
chairman said.
a longer period of time had taken place.
Yes, sir. So essentially, the suit that would be filed within 1 year could now be filed within 2, and the explanation that they gave me was the amount of information that could be kind of lost to history by that time may be more significant, which would impede their ability to provide an adequate defense.
So the thought process is that if you wait 2 years before you go out and find facts, it's going to be harder to find the facts than it would be if you had gone back within a year.
Yes, sir.
So it led you all to believe that it would increase the prescriptive period would increase cost, not decrease cost.
Essentially, it would lead to more settlements. And then there were other pieces that we touched on.
And why would it lead to more settlements?
Because the state would not be able to adequately, in their opinion, defend themselves in a jury trial.
Because going back after 2 years is going to be more difficult to get the facts than it would be after 1 year.
Yes, sir.
Therefore, it would lead to more jury trials with less information, therefore higher settlements.
Yes, sir.
That was.
Yeah, more settlements.
That's what I'm reading.
Precluding a jury trial.
Okay. Listen, I appreciate that, and that's what the chairman said, so I appreciate that. Representative, did you see in the paper this morning about the ratings in the state of Louisiana that we now 50th U.S. News and World Report, or that rates the states. Louisiana is the 50th state in the union. They use 10 different items to evaluate. And listen, I can't tell you how good it is or how bad it is, but they use the educational system within the state, the wealth of the state, the business community, how they're treated, a lot of 10 different items, and Louisiana has fallen to 50th. Did you read that?
I saw the headline. I didn't read the article.
It was an interesting article, and I'm sorry Louisiana has to be there. Kind of leads me to believe, we like at the bottom, we're still digging. We hadn't dropped the shovel yet, so maybe a bill like this would help us do something to stop digging, huh? What do you think?
I agree. Thank you.
Thank you, Mr. Chairman.
And if you wouldn't mind filling out a card for us, we'd appreciate that. Is that it, Senator Donahue?
Yeah, thank you, Mr. Chairman.
All right. Senator Gaddy, and I'm not sure, maybe don't get up just yet. There may be more questions for you.
I'll sit tight, sir.
Thank you, Mr. Chairman. I just kind of go to this a little different way. Since last week, I went back and asked that question, why are we even here on this? How did this bill come about? And why are we spending so much time on it? And then I went back and I asked for some documents. I asked for a ton of documents. I expected to get a 5-ring binder, and I got 35 sheets of paper. Last year, this body and the House unanimously passed HCR 47 and SCR 55. Those documents gave unlimited power to a task force to figure out, we all know our rates are here, let's at least get them to here. We'll never get them down to Maine, but let's at least move them down. So whenever we as senators vote on something like that on the floor, we expect a thorough investigation. As we say back home, that all the nooks and crannies will be looked into. That it will be a ton of evidence put before a subcommittee that has subcommittee upon subcommittee, and that they will look at everything in the matrix to determine whether or not we can change the situation we're in. And whether it's Med-Mal task force or drunk driving task force, and every task force from foster care or anything that I've been a part of, we spend a lot of time and meet many, many, many times. Now this bill is the result of all those meetings. And so I said, well, I'm just going to skip Mother's Day, and I'm going to listen to all the audio. I know it's going to be 10 or 12 meetings and all these experts coming in. And they sent me an email on Friday and said, we only met 3 times. One of the biggest issues, the biggest bill of this session, culminated from a specialized task force that met 3 times. Now, how many of y'all are here today and you knew that the biggest bill that people have been working on for a year since we got out last year, the loggers that are here, the truckers that are here, the moms and dads buying insurance for their people, met 3 times. And you were the chairman of that task force, correct?
Correct.
Okay. I wanted to ask you about that because it's going to directly relate to this fiscal note. And after I get this fiscal note today and I read through the task force subcommittee report, none of this surprises me. I'm the only one not surprised today by this fiscal note. I'm the only one not surprised because we assumed when there's a special subcommittee and task force, and then I get 20,000 emails about House Bill 372, how people are going to leave the state if this doesn't pass. See, we assume on this committee that the work has been done, that all the nooks and crannies have been looked into, and we don't need loggers to come testify in Jud A after a special subcommittee report. Just like in the foster care situation, we have a foster care task force. We don't need parents to come testify at a committee meeting because all of that evidence, those hours and hours and hundreds of meetings have been taken care of outside the hearing. It's a legislative efficiency that we have in place. So y'all met 3 times, September the 13th, which we don't have the minutes for that meeting. They're not available. You met October the 18th, and there are minutes for that meeting, basically just people with PowerPoints and people that have already testified here today or under this bill. And lastly, y'all met on November the 14th. That's the meeting I want to talk about, because at that meeting, y'all said these are the 10 things we want the actuarial subcommittee to look at. These are the 10 things. And I believe, listen to the audio, I think it was Senator Bishop who sat on that task force. He said, don't we need some kind of deadline for this to come back so we can prepare legislation? Which I thought was a wise question to ask. And Mr. Chairman, Representative Talbot, you said, yeah, let's make it March the 1st. Let's on March the 1st, let's come back with the actuarial subcommittee report and let's have our meeting. Let's make our recommendations. And everybody, just like popcorn, shot off the things they thought from the 2 meetings y'all had, the 10 or 12 things that y'all thought would lower rates. And you handed it off to the big brain people whose crystal ball is not broken like ours. They sit down every day and they're called actuaries because they actually know what they're talking about when it comes to numbers. That's where the name came from. I had to look that up to make sure no one would attack me on that. But these guys actually know. They don't sit around and talk about theories or anything like that. They know that the price of tea in China will affect Apple stock and Bossier this way. You see what I mean? They know. And we can't know that. That's why we have these subcommittees. So this task force, just to save you all the hassle of listening to the 5 hours of testimony, the Special Louisiana High Auto Rates Task Force met 3 times. They called a few witnesses, had a few PowerPoints, and they decided, hey, this is over our head a little bit, so let's get the actuaries to look at it. So on February the 19th, so the last time they met as a committee, was November the 14th of 2018. So December, January, February the 19th, the actuaries who actually know how these things affect insurance, they wrote this 23-page report. The first time I saw this 23-page report was on Friday when I was home feeding my chickens, and I said, you know what, there had to be a report from that. You can't have a subcommittee without having a report. Where's the big brain report? Where's that guy who wrote his thesis in college about actuarial stuff? Where's his report? And he wrote one. And the reason I'm not surprised by this fiscal note is because pretty much everything we're saying today, and like we're discovering it for the first time, like the very end of Scooby-Doo, and we're all really worried how this mystery lead us here. This guy figured this out on February the 19th. So my question, Mr. Chairman, is why didn't y'all meet after that report came out?
We should have met.
But I know you should
Not
have,
me.
but the question I want to ask you is, were you disgusted?
No.
Were you upset? I
No.
mean, were they not going to let you use the commissioner's building anymore? I mean, what reason did y'all not meet after this 23-page, in-depth, very expensive report to put together? Why didn't y'all meet after February the 19th? Because you had to give, and I sit as vice chair of Senate Insurance. I was waiting on this report. I did not get this report. In fact, when I asked for all the documentation of y'all's task force, I was sent all the agenda and the minutes. I was sent 8 pages. Then finally, as I listened to all the audio, I said, hey, in the 3rd meeting, they said we're sending everything off to an actuarial subcommittee report, for a subcommittee report. And I know you remember that meeting in November. Y'all said, does anybody else have anything they want to put in here before we have the actuarials look at it? And I think several people made suggestions, and then this report was the result of that. Now, this report was due to Senate Insurance and House Insurance by March 1st. Could have just emailed it to us, a copy of it, sent it to us, and I think y'all anticipated to meet after February the 19th. So I just want to make something clear. House Bill 372 is not a result of the task force, correct?
No. It is not a result of the task force, and I never said it was. And I
Okay.
hope I didn't
Well,
mislead
now,
anybody
I wanna-
thinking that.
I want to
And-
make that clear because I'm getting emails from loggers saying they don't trust me anymore because this task force met, and I'm not taking the recommendations of the task force.
This is not a result of the task force. For me, the task force helped me out a lot because I did learn a lot. We did study a lot of different issues. Same thing we've done when I sit on the Property Casualty Board. It's the same issues that board has been recommending to the legislature for years. But, we should have met again once the actuarial report came out. I made the call, and maybe it was the wrong one, maybe it was the right one, not to meet again. That information should have gotten to you, and I apologize for that.
Did you read the actuarial report before you decided not to meet on it?
No.
Have you read the actuarial
I
report?
have read the actual report, and it doesn't look. This fiscal note doesn't surprise me either. It is undeterminable. I mean, there's no way. It's very difficult.
Well, have you heard
to
us
see.
asking every day what the actuaries say? When we're in insurance committee, we say, what are the actuaries saying about this before we vote on it? We ask for two things when it comes to insurance. What are the people who actually know, the actuaries, who are going to set rates? I mean, what are they going to say, and what's the fiscal office going to say? Those are both people you could have had testify in your task force, correct?
Correct.
Okay, and they didn't testify at your task force, did they?
We did not meet after the actual report came out.
All right, so y'all had the 10 things you were concerned about, right? And you
Right.
only sent those 10 things, right? So how did you boil it down to those 10 things?
We just opened it up to the floor for people to, we didn't vote yay or nay on any particular issue. We said if you have an issue that you want the actuarials to study, now's the time.
Do you have a copy of this report with you?
I don't believe I do.
Okay. Do you think it's
But,
something?
I'm sorry, go ahead.
I mean, because if we would have had this report on March the 1st, we still had time to do other pieces of legislation that would have actually lowered rates.
Senator, I'm not preventing you from studying this issue and from filing bills that deal with this. You're a smart guy. You're an attorney. You're in this industry to some degree, I believe, and I am not holding you back on looking into this on your own. I don't need a task force to do a bill, although this was an important task force. Yes, we should have met more, but I'm not preventing you from filing legislation to deal with this problem if there
That's
is
not my
even
question.
a problem.
I filed 60-something bills.
I know you
20
did.
passed. Nobody's told me I could never not file a bill.
Right.
That
I
wasn't my
understand
question.
that.
My question was, did you read this report before you filed House Bill 372?
I read the report before I filed it, but
Okay.
when I read the report, it wasn't a shock to me that they couldn't determine, that they were pretty much all undeterminable. I mean, it's hard to quantify those things. You can't look at a state that had a 40,000 jury trial threshold and lowered it to 5, or, you just don't have that there. You don't have a state that had a prescription period. I don't believe those have been changed that many times. There's only 3 that have a 1-year prescription period. Everybody else is 2 or more. So it did not surprise me to see the fiscal note or the actuarial report.
But there are
That
some.
wasn't a determining factor whether I was going to file a bill or not.
Well, I understand that, but I think what the public has kind of meshed together in their mind is you have lobbies saying this is the most important bill of the session to lower rates. Okay?
Okay.
You are the chairman of House Insurance, and you are the chairman of a specialized task force that was chartered and mandated by the legislature to have all the rights, power, and authority of the legislature to determine why our rates were so high. And then those two things have happened, and then we have House Bill 372 authored by you. And the bill is what the bill is. But when I got this actuarial report and I flipped to the page on 2-year prescription or collateral source or jury threshold, all of these are inconclusive that these would lower rates. Now, my question is, why didn't y'all go back with the authority you had the task force and have somebody like Mr. Heller come guide you to ways to lower rates? Did someone exclude that kind of thought from the task force, or did y'all just not have time to get to it?
No thought was excluded from the task force.
So if somebody was to say, I really want to have Mr. Heller come in and talk to the group, you would have allowed that?
Sure.
Now, most of the talk was about distracted driving and bad roads. Do you consider those two things pretty?
I wouldn't say most of the talk was that. I said it was definitely brought up. It was definitely brought up, and I know we have some legislation. I believe Representative Hubal has some legislation dealing with distracted driving. That is an important piece of this puzzle.
So do you think if we're not going to use the actuarial report from the task force to determine what bills we pass or don't pass, and we're just going to use people's emotions and emails they get from lobbyists to say if this bill doesn't pass, everybody who votes for it's getting a 0%. I mean, to me, if somebody's going to say that, and if you're going to draft this bill, it better have something in it that'll lower rates. And after reading this actuarial report, which is from your task force, there's nothing in this report that says any of the 4 factors within your bill are going to lower rates at all. And I'm not sure how we can say I'm going to turn it over to a subcommittee of actuarialists. so that they can tell us whether this is effective or not, and then totally discount what they say. When they say these 4 things could drive up cost, they could cause us not to have investigations in the time that we need, that even with the seatbelt law, your actuarial said this, and I'll quote it. Because seatbelts have been made a primary issue in this, not whether you're a widow, not whether, your income or buying power, which every other state has done. They've said you can't use buying power, widow status to set someone's rates. Here it says that most people that don't wear their seatbelt are already kind of, they don't recover much because they also fall under no pay, no play. That's what your actuarialist said. So I guess I'm just trying to bring together in my mind, if we don't understand something, we hand it over to the financial people or the actuarial people. And I'm not sure how we came up with these 4 items after the task force. So I appreciate your testimony that this bill was not a result
No,
of
those
the
are
task
items
force.
that I put in, but again, Senator, if you want to vote against the bill, vote against it.
Well, because
And-
I know that's going to be the catchphrase here, but I want to tell you this. I've told you since this task force started that I'm 100% behind you if it lowers rates.
Well, Senator, I don't think there's any possible way that you can, it's going to be very hard to say definitively if it will. I believe it will. If you look at what we're doing, we're aligning ourselves with other states that don't have direct action, that have a 2-year or more prescription period, that have, you're such an outlier in jury trial threshold. We're trying to look at what other states are doing where their rates are lower. But I know it's a
Representative-
difficult thing, and let me stress this too. I did not work in collusion with any lobbying group to do this bill. You've mentioned the lobby several times. They were not happy with this bill in regards to some things in it.
the 2-year
insurance-
prescriptive period.
Right. The defense attorneys did not like things in this bill. The trial attorneys did not like things in this bill. The insurance company did not like things in this bill. So, it's something that, this bill has my name on it, and I'm proud to stand by it. I think it's a good bill. I think it's going to create competition, and I think rates will go down. And I think what we're trying to do here is not put us into some stratosphere like, we're going to be the only unique state that has this, or this. But again, my name's on it, and I stand by it, and I respect your position, whatever you end up doing on this. And the discussions you and I have had, you've enlightened me on a lot of things, and this is a process where we're understanding as we go.
So we have a bill before us that we don't know whether or not it's going to lower rates, and we don't know how much it's going to cost, and you want us to vote on that.
My bill is my bill.
Okay, thank you.
All right, well, I was about to say the board was clear. Senator Donahue.
I would like to make a motion, report the bill favorable as amended.
All right, so we have a motion.
I didn't mean, he didn't close, and if you want to let him do that.
I'll waive my
No, he's
closing.
welcome.
I think that.
Okay.
I
He's
don't wanna-
probably
and I-
exhausted and doesn't need to close. Yeah.
I'm fine.
I think we've thoroughly heard the issue. You're welcome to close.
No, I'll
I appreciate
defer
the
to the
candid discussion.
No, look, this has been a fine experience here, and y'all,
And look, I don't want
Fine.
anybody to feel like they came here and didn't get to testify. Last year, feels like it's been a year.
right.
Last
Right.
week we had the full hearing. Today, the purpose of today was really to get to look at the fiscal note and to allow you to close. And so we still have a pretty lengthy agenda to cover. So
I'll waive my closing.
we're going to do that. So we have a motion from Senator Donahue to report favorably, and then we have Senator Luno.
Mr. Chairman, I want to make a substitute motion. During the course of this session, we have heard lots of testimony dealing with HB 372 that we're here on today, as well as my Senate Bill 89 that was in the Insurance Committee here in the Senate. When I first read the bill that's titled the Omnibus Premium Reduction Act, I thought to myself, there's not anything in this bill that's going to reduce premiums. I thought there was one thing in it that might help to reduce cost, and that was the 2-year prescriptive period. But like I told you before, Representative Talbot, I practiced law for 28 years now under the 1-year prescriptive period. I mean, we can get by with it. I think it costs us more because we have to file suits when otherwise we have a little bit more time. We make it settle it, but we understand where we're coming from on that. I thought that probably the public's perception was going to be that this bill would reduce insurance rates, and I was right in that assumption. I've gotten calls. I've talked extensively with constituents and folks in other parts of the state as well, and everybody believed that this bill would reduce rates. I don't agree with that. I've been practicing law, like I said, 28 years. I know this system. I know what happens and what the net effect of it is, and it's just not going to do that. We hear on these things, some of the things in your bill, direct action that would prohibit a person from being able to sue the insurance company directly. And it's difficult. It's a legal concept that's hard for people to understand if they don't understand how the procedure works. But an analogy that could be made to this recent case where this barge hit a bridge here near Baton Rouge, and they did a limitation of liability. They limited their liability to the value of the vessel, and the state had to pay the remainder for what the damage they did. That's a good way to analogize it. We're limiting ourselves in what we can do and who we can sue. And make no qualms about it, Representative Talbot. When you can't sue the insurance company, they are not a party to the litigation. A party has to be named, and you have to prove all kind of issues with that for somebody to be a party. The venue's correct, they're the proper person, all those things. So they're not a party to the litigation if you can't bring them into the suit. One of the most interesting things throughout this debate that I found was the candor of the insurance industry, who testified both in this committee and in my bill over on Senate Bill 89 that nothing in this bill would reduce rates, not a single thing. They were very forthcoming about that, and they told us that repeatedly. So when, again, Senator Gaddy mentioned, when Lobby comes out and says you're going to get a 0 rating for the session if you vote against this bill, it just doesn't make sense to me if the object is to lower insurance rates. I think there's another object. I think this is a wish list for the insurance industry, and that's what they're trying to do. They're trying to limit people's access to courts without giving up anything in return. And they always say, and we hear it all the time, well, hopefully if this reduces rates, hopefully it's going to make rates come down. If it reduces costs, rather, it's going to make rates come down. But they never want to guarantee anything. They never want to say, well, we'll reduce your rates. And that's the reason for that, is because of what those gentlemen testified. All they're going to do is increase somebody else's rates because they're going to make their profits. And I'm not against them making profits, but I think one of the things we need to do is we need to balance what we do here by protecting the people that are damaged in regard to what the rates are. Now, there were lots of folks that came in here and testified about commercial insurance rates, and they hoped that this bill would lower those rates. We heard testimony from some of my constituents here about how high their rates were on their log truck. It made me look at it a little bit more carefully too, to try to figure out what is something we could do to help with those rates. But what we found out is in Louisiana, there are only 2 companies that write for log trucks, 2 in the whole state. And those premiums are very high. We know that. And it made me think about something that you had said, Representative Talbot, in committee that I agree with. You said that line is not competitive because there's only 2 companies that write those. Well, I agree. I think any reasonable person would agree with that they are competitive. But guess what? Our Louisiana Department of Insurance has said for years it's competitive. They said it this year, in fact. How can that be so? Well, when they do that, there is a law that deals with that, and when they say it's competitive, it limits what can be done to change insurance rates in the state of Louisiana. That's a problem. That's something that we need to address. But unfortunately, this bill doesn't do that. So, having said this, I don't believe that we should pass a bill that only reduces the access to courts, reduces the amount of damages that are paid to people, increases the cost involved in it, because, like the fiscal note said, it's going to increase cost. We've heard testimony from everybody involved in the court system that said it's going to increase cost. It's indeterminable how much it's going to increase it. We understand that. They talked about in the fiscal note what the things it would do that would cause the increase. I can tell you this. I don't have empirical data, but my best guess would be right now that the cases that are allowable as a jury trial now, in other words, cases over $50,000, are probably somewhere between 25 and 35% of the cases that are on the court's dockets across the state. If you lower it to $5,000 or $20,000 or $15,000, whatever that number is, you're going to exponentially increase the numbers of cases that go to jury trial. And the reason for that is because that's the majority of the cases that are down there. In addition to that, you're going to take about 75% of the cases, or maybe 80% of the cases, depending on the number, from the city courts, and you're going to push them over to the district courts. And you're going to, the problem's going to multiply. Louisiana does not fund the court system. We only pay the judges' salaries. Everything else is paid for on the local level. And we don't have the money to do that. We don't have the money in the state to do it either. It's an unfortunate situation, but we can't piecemeal this thing into making it where courts, the access to courts are limited, and we don't reduce insurance rates. So for those reasons, I'm going to offer a substitute motion to defer this bill.
All right, well, we'll hold on to that for a second. We'll go back to Senator Donahue. And look, everyone up, I know this is lengthy, but I do always think it's very good to let everybody, all the members, have their say to a certain extent. A lot of people travel to come and maybe say their piece at the table, or just simply participate or hear live the testimony and all those things. And I certainly think as members of the legislature, I always am very hesitant about ever cutting a member short of letting them say what they feel is necessary to say. Senator Donahue.
Thank you, Mr. Chairman. So when I moved to report this bill favorably, the reason I did that was because I think the bill's a great bill. Thank you for bringing it, Representative Talbot. And I can't help reflect on how it passed through the House. It was like 60-30, so it was an overwhelming passage of the bill. I have an idea how we can reduce costs in the state of Louisiana. Let's reduce the amount of money that attorneys can get from these suits. Let's put a cap on that. I think that would reduce cost. We're second highest insurance rates in the country. We're last in just about everything, but let's not take a chance and do anything that might work. Senator, I can't tell you it's going to work. Nobody can. But what I'd like to see, I tell you, if we could just slow the growth of the insurance rates, I would think that we might have a win there. And then all these years we've been fighting 2-year prescriptive period. Now we have a fiscal note that says if you do that, you're going to increase the cost, not lower the cost. So I mean, it gives me reasons for concern, but I do want to move favorable. And Senator Leno, I appreciate your position on that.
All right, so finally the board's clear, and we had a motion, then a substitute motion. So, Madam Secretary, if you'd call the roll, please.
On defer.
Yeah, the substitute motion is the motion.
To defer.
To defer.
Yes, we need to defer.
Senator Luno?
Yes.
Yes. Senator Bishop?
Yes.
Yes. Senator Donahue? No. No. Senator Gaddy? Yes. Senator Milkovich?
Yes.
Yes. The motion passes to defer 4-1.
Thank you, Mr. Chairman. Thank you, Senators.
Appreciate your time.
Thank you.